Good afternoon, everyone. Welcome back to our latest episode of all things related to business immigration in the United States. My name is Charles Raether. I'm the managing partner at AmLaw Group, where here at AmLaw for over 15 years, we've been helping people make a successful and comfortable transition to the U.S., whether you're an entrepreneur, an investor, a talented professional. And we like to focus on aspects of business immigration that are most relevant for our listeners and viewers. And today, as oftentimes, I've got my colleague Alexander Verbinsky with me to talk about today's topic. Alex, how are you doing?
Very good, sir. Thanks for having me.
Absolutely. Good, good. So today I think this is kind of like recently we did a podcast on L-1 visa. And today I think we're going to continue on that conversation and discuss an aspect of it that comes up a lot of times is we're going to do a deep dive into a comparison of L-1 and E-2. Because any of our viewers know you're kind of the E-2 expert. You've cut your teeth on that, working with a lot of Canadians, UK, other citizens and whatnot. As we know, E-2 is a very versatile, convenient visa, but there could be cases where the L-1 might actually be better, and I think maybe you've talked to some, potential scenarios and clients on that aspect too.
Yeah, 100%. So obviously, the L1 has that immigrant intent. You can have immigrant intent. And I think that's very important for some people that are operating larger businesses that sort of want to expand into a new business into the States
Yep.
or other different scenarios. But I think that's what's key. A lot of E2 listeners and E2 individuals that I have conversations with, they always mentioned a little bit of intense, and but except they want
Just
the
a little
E2
bit, huh? They don't
visa,
wanna be
or
too
just a
obvious
little
about it.
bit, just a little bit.
Yeah, yeah. Well, that's true, I'll be honest too, I would probably say the majority of our E2 clients too probably harbor those immigrant thoughts as well. I mean, let's be honest here. But as we know, an E2 doesn't offer us a straightforward path to a green card, and so despite all the advantages of an E2, that is one downside with it. And I think so. Let's dive in, talk about some of these differences, and I think this is going to be a really interesting podcast for everybody because we'll talk about scenarios where E2 might be better, L1 might be better, or it might just depend on the business plans of the clients and the company in particular. And there are certain scenarios where L1 might in fact be better. I mean, I'm a big fan of E2, and I'll be honest, most cases when we've got an opportunity to do either an E2 or an L1, I'd have to say probably the majority of the time clients tend to go with the E2, but that's not always the case. And hopefully, we'll dive into some of these options and talk about these various scenarios where it might even better to go with an L1. L1, absolutely.
Yeah, yeah, it really is case by cases, I presume, right? I mean, depending, what the future plans are of our clients and their company, we'll be able to suggest and cater, our, let's say, consultation to their needs, right?
Yep, absolutely, absolutely. So I'll try to share my screen. We've got a little kind of a brief audio visual or a presentation that'll kind of help go over some of these options and differences between E2 and L1 because just listening to you and me talk might get a little uh, tiresome and confusing. So everybody likes nice fancy pictures and words and stuff like that. So as we were talking about, E2 and L1, again, the goal more or less is the same. It's either to expand your business in the US or, do it if you've got a startup that you want to, come to the US, you have no operations here right now, or you might have operations currently in the US and you want to expand and grow that footprint. Um, so, and when we talked about some of these things, it depends, are you looking ultimately for a green card for yourself or maybe some of your employees? What country are you coming from? Do you even have the option for an E2 or not? And do your employees even have the
I Is the L1 actually available to all passport holders? I think that's
Yeah.
that's an
Yeah, that's
interesting.
that's a very good point. Absolutely. Yeah. And that's a very big upside of an L1. So it doesn't matter whether you're Canadian, Indian, Pakistani, Chinese, whatever, L-1, even Russian, right? I mean, even we have Russian clients sometimes, I think because of the ongoing conflict in Ukraine, they think, these options are closed off. So literally L-1 is available for anyone. But if you're looking at an E-2, you have to have a passport from a treaty country, and, many people don't qualify, in that regard.
Okay. Yeah, that's great. And then like in addition to that, I think the L1 is definitely uh great because I mean you can offer some sort of opportunity to your employees in the foreign company that you're running, right? So
Mhm.
the E2 is obviously, as mentioned in our previous conversation, the E2 is limited to only the same nationality of the E2 investor, and then the L1 could be open for any nationals working at your foreign company
Yep.
for 1 year in the last 3 years, right? So it definitely
Sure.
opens up the floodgates and the opportunity and sort of like your company offering to your employees, right?
Mhm.
If you stay with us, if you do a good job, we could transfer you to our, U.S. subsidiary, and you could work with our team down there, right?
Absolutely, yeah, yeah. So I can see that easily happening. Like, say a scenario, it's a Canadian company or a UK company. So yes, if you're the owner of that Canadian company, sure, you could get an E2 visa. But if you have some personnel that work for you, maybe remotely, maybe within Canada or the UK or wherever you are, but they don't hold Canadian citizenship, they can't, come to the US on an E2, unless they have citizenship of the main investor. So you very likely, especially if you have a multinational team like you're mentioning, and you might have people working for you who are from, different countries all over the world. Even if that other person's from a treaty country. So say, for example, you got a Canadian company, but you got a Brit who's working for you. He can't come over on the E2, even though there's a treaty with Britain, because you have to have the same nationality as the owners of the company. So yeah,
Great.
L1 could be, yeah, good, HR, motivating factor, for
Yeah.
your employees as well.
Yeah. That's
Yeah.
great.
Yep, good point. So here's kind of a summary of kind of the differences between the E2 and the L1. And then so, y you know, maybe I'm not gonna go through every, item here, but I would say definitely one thing that a big difference between the E2 and the L1 is the E2, they really kind of focus on the investment, right? How much money you putting in? Have you invested and spent that money? And what are you gonna spend the remaining money on, for, right, through your US company? Whereas with the L1, they're really looking more, it's based on, transfers within the company, and what I would say is it's really based on the employees, right? So like here it says that, the gate is 100,000 or so investment for the E2. For the L1, what we have to show is you have adequate employees overseas, and you will have adequate, employees in the US after you launch your operations. Or if you've had operations in the US already, that you already have that sufficient number of employees. I always kind of like to remind people to remember, look, with the L1, it's kind of a pyramid structure for the personnel, right? You've got the main, say president, general director, CEO at the top. Below him or her, you have at least two managers who have a higher education. And then below those managers, you have the regular employees. That structure you need to have both at the foreign company as well as at the US company.
Hmm.
Whereas with
Hmm.
E2, they don't really care about that. E2, it doesn't even matter if you had your own company overseas, and they don't really care generally how many employees you get, in the US. Um,
Yeah, like in public companies, do they have to
yep.
have a certain percentage ownership of the company, or is the title sufficient to say that I'm the CEO?
Title's sufficient. Yeah, yeah, title's
Yeah.
sufficient. Yeah,
Okay.
yeah,
Okay.
yeah. So,
Very
yeah.
interesting.
I would say so, and again, this is, a subject for a future podcast, right? Talking about if we're dealing with larger multinational companies that are coming over to the US, or if we're dealing with smaller family businesses and stuff like that, kind of the approach is different. But certainly that scenario you just gave, if it's a larger, even a publicly traded company, yeah, the E2 just isn't going to work for that, because just imagine, I mean, if you're publicly traded, how are you going to prove the nationality of the company, that the majority of the shareholders are from a particular country to qualify even for the E2? I mean, it's not even feasible, right? So, yeah, with larger companies, I would say, yeah, generally the larger the company, the more likely you're going to have to use the L1 as opposed to the E2, for those reasons. Um, And, again, we have another podcast where we talk a little bit more detail about the L1 and the differences here. But in the lower right-hand corner, you see it mentions the L1A, L1B. I should maybe just mention for people that aren't familiar, there's two types of L1 visas. L1A is for executives and managers. L1B is for what's called specialized knowledge employees. So L1A, that's your CEO, your CFO, people that are either executives of the entire operation or they're managers of very important functions within the company. The L1B is for more specialized people. They don't even have to manage anybody. They just have very comprehensive knowledge about certain aspects of your operations or maybe equipment that you're using or stuff like that, that you make the argument that, hey, it's very difficult, if not impossible, to find similarly skilled employees in the US, and therefore we have to bring these people over on this L1B. So with larger operations, larger kind of publicly traded or just large companies, you'll see a lot of L1B visas more often just because, they've got a lot of proprietary in-house maybe, software procedures, work processes, how they do. And, they say, look, it's going to take us years and years to train somebody in the US to be able to do that here. So we need to bring this person over.
So the difference between the L-1B and the E-2 employee visa, all right? What is the proof? Is there any sort of differences in what our side has to work on proving the essentialness of that employee?
Yeah, that's a good question. So, for those who don't know, what Alex is referring to with the E-2, besides the investor E-2, it's also possible to get an essential employee E-2. So you're right, they're similar between that essential E-2 employee and the L-1B. Um, it's a good question. I guess I haven't thought about it a lot. What's the difference? I would say generally speaking, I think it's a little bit easier to prove, the E-2 essential employee, generally speaking. With the L-1B, there's certainly more L-1B applications out there than E-2 essential employees, and as a result of that, or maybe that's not as a result, but I think the USCIS is a little stricter in terms of how they evaluate L1B candidates. Um, I guess, I can't say why that is. So I would say with an L1B that the hurdle you've got to clear is a bit higher to prove, hey, this person is super important and we really need him. Again, if it's a larger operation that you're talking about, that tends to be pretty doable because you could say, "Hey, look, this guy has been working for us for 5 years." You know, who am I thinking of maybe? I know some people that were working for, like, real estate consultancies, it was an international company, and they just said, "Look, this guy's been working for us for 5, 10 years. He knows all our methodologies and how we do our valuations and stuff like that." And, even though you could train somebody to do all this, yeah, it would take quite a long quite a bit. So I think they're very comparable. It just kinda depends, on the exact, facts of the case, which is more difficult. Um
Yeah, gotcha. I think we quickly spoke about it on the last conversation we had about the L1B, in the reasoning behind you needing to work 1 year out of the last 3 years at that foreign company before you can transfer
Ooh,
over
yep,
to the US one, right? And it's because, there's certain skill sets that you could learn in 12 months. And then that skill set, I mean, might as well bring that foreign employee over instead of having to train someone at the US office, right? So it'll sort
absolutely,
of
absolutely.
ramp
You're
stuff
you're
up.
on the ball, Alex. Yeah,
Okay.
absolutely. Yes, I did forget about that component, and that's something, that is a big distinguishing factor between the L1 and the E2. So, the E2, you could have hired the guy just 2 months ago at your foreign company and said, "Hey, he's an essential employee. This guy's, knocking the doors down, and he's just awesome. We need him here." And even if he's been working there only 2 months, yeah, it probably would work. But with the L1, absolutely. And this is true for both the L1B and the L1A, that any candidate for an L1 needs to have at least 1 year of experience working for your affiliated overseas company. So,
Great.
yeah, yeah, that's a big key distinguishing factor that whatever it is, L1A, L1B, you can't just hire somebody off the street, a month or two. prior to filing for the visa. So the L1 is definitely more of a long-term kind of commitment that you can show, hey, this executive or this skilled employee has been with this for over a year, and we want to send them to the US right now. Yeah. So yeah, that is a good. So, I think, these slides, we've kinda talked a lot about this, these factors here. I think maybe the one thing maybe I wanna emphasize here with the L1 is for an L1A, it's a clear path to an EB1C green card. It's very straightforward, and why do I say that? Because a lot of the requirements for the L1 for the EB1C, for the green card, they're very similar to the L1A. So I can't guarantee if the client got the L1A, I can't guarantee for sure that they're gonna get the green card and the EB1C. But in most cases, if the business in the US is doing okay and it's growing okay and it, achieves, certain, parameters in terms of its size, level of employment, stuff like that, it's a pretty easy transition from an L1A to a green card through the
What
EB1C.
when do we typically start working on that EB1C, like, let's say, case, and then be ready to submit it, for the L1A? Because we know that for the L1A, you need to have it, for a year before you can consider the EB1C. So do we start working on it? Let's say they meet all the parameters and all the milestones, and they have those 8 employees. Can we start, assisting our clients, at month 8, to put the application and or the case together and then
Well,
submit it
yeah,
by
yeah.
month
Yeah,
12?
yeah, yeah. Yeah, yeah, absolutely, absolutely. I think so again, there's kinda 2 scenarios with an L1 when we're talking about that transition to the green card. So, remember we talked about there's the existing US business scenario and there's a startup US business scenario. If they have an existing US business and it's been operated in the US more than a year and it meets all the requirements, and maybe we won't go into all those requirements right now, but if it meets all the requirements, you could theoretically file for the green card right away. You don't even have to file for the L1A. They could file right away for the green card. Now, do we do that all the time? I'd say it it's relatively rare for us to file immediately for the green card, and that's almost like, you're a baseball player, and you're swinging for the fences, right? You wanna get a home run, whereas we think it's generally better to get a solid double or a triple, meaning get the L1A, get that secured. The requirements are a little bit lower for the L1A, even though theoretically you could qualify for the EB1C. Let's just get the L1A, get the executive over here, and then from once they get here, we could wait a while or we could immediately file for the EB1C after they get the L1, just so you kinda have an insurance policy. Now, getting back to your question, the startup US company scenario, that's what I think you're addressing. Let's say they haven't had extensive operations or any operations in the US. It's new business in the US. They started it up. The guy got his L1. At what point do we start preparing for the EB1C? Well, as we just discussed, to get the EB1C, the US company has to be operating for at least a year, and it has to have at least 8 employees, ideally a few more, but at least 8. So, at any point after having a year of operations, we can theoretically file for that green card. Now, how soon we file really depends on the client's needs, the condition of the business, and these other factors, right? I mean, sometimes clients are really in a big rush, and we're like, look, you don't have enough employees, or the employment structure isn't the greatest, or there might be some other factors, and we might be pushing them back and saying, look, let's do it right, but let's take a little bit more time. But to answer your question, um, if they're in a rush and they otherwise kind of meet most of the requirements, sure, we could start planning for the EB1C already, at month 9 or something like that, month 10, so that once we clear, that 12-month hurdle, we could file. Now, here's another practice pointer I might add. We generally, in that kind of scenario, so again, startup scenario in the US, you've had operations going to 8, 9, 10 months, you wanna file for the green card as soon as possible. And let's say at month 12 or 13, they wanna file. We almost always file for the L1A extension as well, because again, it's just like a buffer. It's a security an insurance policy, right? Because if they just file for the EB1C at month 12 and they get denied, you're kind of out of luck, right? I mean, you're not going to have a valid status here. You could refile the EB1C. You could file again for an L1A, but you're going to have to leave the country, go through the embassy, and then come back. And most people don't want to do that. So we generally file the L1A renewal at around month 12. We make sure they get that secured, and then we file the EB1C.
Gotcha. Okay, and I love scenarios, and I think a nice scenario that I have is, if someone has, let's say, they launch their U.S. company, they hire two employees off the bat to sort of help with the process, and then they don't employ anyone up until, let's say, month 8, 9, right? And then they create that hierarchy, that structure. And those employees have only been working for them for, let's say, I don't know, 7 weeks, very,
Yeah.
very minimal employment length. Is there a certain time span that has to go by when it comes to the employees that you've hired in the US before you could apply for, let's say, or not even apply, just to be in the good of in the eyes of USCIS?
In the good graces? Well, that's a very good
Yeah.
question. So, good scenario. So, startup US scenario. 6, 8 months go by before they hire their first employees. And you're coming up on month 12 and you're thinking, okay, do we renew the L-1 or do we file for the EB-1C? And let's say they got 8, 9, 10 employees in the US company already. So, on its face, you'd say, well, pretty good. You can even maybe file for the green card. What I would say in a scenario like this is do not file for the green card because they generally want to see that you have that full employment level at least for 2 quarters. So that's about six
Mm,
months. So if
okay.
you only started hiring, or you reach that level of eight or so employees only at month 8 or 9, you're going to shoot yourself in the foot. I mean, it
Yeah.
might get by, but I think it's quite likely it wouldn't. Now, the good thing with the L1A is there is not that 2 quarter, 6 month kind of requirement to have those employees. They just want to see by the time you're at month 12 and you want to renew that L1, are you at that employment level? And so even if you just hired them all in the last couple weeks, that should be okay. That
Okay.
should,
So employment level matters only, let's say, necessarily for the renewal and the EB1C, right?
right, right.
But the key thing about the EB1C is you need the employees employed for 2 quarters at least. But for the let's say renewal, you could have them employed for 2 weeks prior to filing that
Yep.
renewal.
Yeah,
Right.
theoretically,
Okay.
you do.
Got
Yeah,
it. Okay.
that was
We
good.
veered off a little bit. I'm
No, but
sorry.
that's a
But
very good
yeah.
very good detour. Very good detour.
Yeah. Okay.
Um, and well, I think this slide I wanted to kind of talk about this too because I think this is a very um, helpful scenario where you can mix and match, right? You're not limited to just doing an E2 for your employees or an L1 for your employees or for yourself and stuff like that. So, like for example, kind of that scenario we had a Canadian company has a U.S. operation. You might have some Canadian employees, and they could very easily qualify for the E2, right? And then you might have some overseas folks that would not, but, otherwise we could bring them over on an L1A or L1B. And so, you know, these folks maybe, depending if it's an L1A, for example, they might have a clearer path to a green card through the EB1C scenario that we are just discussing. But let's say you got some of your Canadian employees and they're on an E2 and they're doing a great job for you in the US. They want to stay here. You want them to stay here. I mean, there's several options, right? You could indefinitely kind of just keep renewing them in the E2 status, which maybe is not so bad. Um, but let's say, for example, the Canadian employee has some children who are, in their late teens and they're close to turning 21. And once they turn to 21, they can't stay here on their mom and dad's E2 status, right? They lose that status at age 21. So that might be a scenario where your Canadian employee comes to you and says, "Hey, look, we got to try to file a green card for me. Otherwise, my kids can't stay. I don't want to stay in the US if my kids can't stay here." So what would you do in that scenario? I would say the most common and probably easiest solution for that solution for employees like that is probably filing for like an EB2 or EB3. So doing the labor perm route, uh, which, obviously you know about and maybe our viewers do. So EB2, EB3, what is that? That's when you have an employer, a US employer, in this case, it would be a subsidiary of a Canadian business, and then that company sponsors an employee. Now, that process is long. It's at least 2 to 3 years, could stretch it as long as 4 years. So, you wanna plan for that adequately in advance before, let's say, the employee's children turn 21. But I would say, again, for E2 employees, the most likely route for them to ultimately get a green card, if that's something you wanna do or, they wanna do, is probably the EB-2, EB-3. But it's a more bureaucratic route. Like I said, it takes probably 3, maybe 4 years, and the salary that gets, stipulated when you're doing the EB-2, EB-3, that gets set by the Department of Labor in the US. So, the employer doesn't have as much control over the salary level. Now, hopefully, you're paying that person, that amount of money anyway, right? But if the Department of Labor comes back and says, "Hey, you gotta pay this person, 80,000 a year or 100,000 and you were paying them less," there might be a little bit of a financial stretch there that you may have to deal with.
Yeah, I got a question on that. So this example is that if the Canadian firm owned by obviously a Canadian individual is opening up a U.S. branch, and the E2 employee visa is still
Mhm.
available to Canadian nationals. So you, the investor, you don't have to have the E2 investor visa for an E2 employee visa to be issued, right? Um,
Ooh,
is that
wow, Alex, you're really going deep. I hope everybody's got their coffee. We're
right?
gonna go.
Because I think that's what we're mainly talking about, right? We're talking about employees that have the E2 employee visa, right? And this scenario is very, very aligned with that scenario where a Canadian individual owns a Canadian company, and that let's say individual opened up a US branch, and they are able to get the Canadians E2 employee visas, and they're allowed to get L1Bs for any other nationalities
Yeah.
that are not Canadian, right? Essentially at that point, right?
What
So
I thought you were
that's what
asking
this
about,
is.
maybe you weren't asking about this, but I thought you made the comment that in that scenario, the Canadian owner might not have an E-2 visa. Is that what you said?
Correct. Yeah, the
Yeah.
Canadian
So
owner doesn't
so
have
that's
it.
so this is yeah, this is a really fine nuance, folks, and listen up because I don't think you're gonna hear this anywhere on YouTube or podcasts because it's just this information's not out there, very widely. So, if you're a Canadian owner and you got a Canadian business and you opened up a US subsidiary or affiliated business or something like that, and you wanna get your Canadian employees over here, and probably the easiest way is probably an E-2, maybe a Treaty National, a TN visa, but probably an E-2, right? You're correct, Alex, that the Canadian owner does not have to get the E-2 investor visa, provided he is not residing in the US. So that's just so if that Canadian person owner is in the US, and I guess it's kind of in the situation of Canada, it's kind of a unique situation because Canadians can travel here without a visa. You guys can cross the border, at any time, stay here for 6 months. So it's not like they have a visa. Of course, that information gets tracked when they cross the border and how much time they spend here. But the important thing to keep in mind is you don't the E-2 owner, the business owner does not need to get the E-2 to send, their E-2 employees over here, provided that person's not living in the US. Now, how do you define living, right? Like, what if you're a Canadian, you come here for 6 months a year, where they start saying, you're spending a lot of time here 6 months every year, we consider you to be a resident. I don't know the answer to that question. That's a gray area. But this just FYI, sometimes we've had scenarios like this come up in the past where the owner might be in the US on an, I don't know, H-1B visa or a student visa and stuff like that. And we had scenarios where they wanted to bring over some of their employees from the country from which, they came, and we said, "Look, you can't do that. You gotta get the E-2 visa first because 'cause you're living here in the US right now." So
Well, sorry, I just want to backtrack a little bit because we're talking about E2 and L1s.
yeah.
We are going to assume that the owner has the L1A visa, okay, as an executive, and that them holding the L1A visa, they're still able to get the E2 employee visa for their Canadian
Oh,
employees,
that's the
or
scenario
no?
you're talking
Because
about. I
yeah,
see, I see,
because
I see.
but at that point they're living in the United States, so
Yeah,
technically
that
the
that would not work.
investor that would
Yeah, that
not
would not
work.
work.
Okay,
That would
all
not work.
right, okay,
Yeah, good
all right.
point. Yeah, yeah. So, yeah. So this is another scenario. Like, let's say the owner, they didn't work with us, they worked with some other attorney, which may not have given them good advice, and the Canadian got an L-1, and then let's say that client comes to us now and says, "Hey, I got a bunch of Canadian workers, they're essential, I wanna give them an E-2 to come over," and the Canadian owner is here in an L-1. We're gonna have to say, "No, sorry, no luck, no luck." And they
Gotcha.
might not qualify for the L-1 because maybe they only just started working for him in Canada recently. They don't have a year of experience or something like that.
Yeah. Yeah.
So
Okay, that's Oh, this is such a good point. I'm so glad we're talking about it because on the E2 employee side, the employee doesn't have to have ever worked for you. They could
mhm.
be just a new hire in general and just come down to the States. Okay. Wow.
Yeah,
That's
yeah, yeah, yeah.
pros and cons on both ends.
Yeah, definitely pros and cons, and that's why, yeah, planning is really necessary, and I'll admit a lot of people, they well, people don't always plan in general, but sometimes it's hard to plan for these things, right? Because maybe the guy got his L-1 thinking, "Yeah, this is the best way for me to go," and then 6 months later, he finds a super rock star employee in Canada who just starts working for him, and he wants to bring him down here to the US, but he can't because he hasn't had a year of experience, so he can't do the L-1, and the owner has the L-1, so he can't bring an E-2, employee. So stuff like that happens, it's interesting. So, yeah, this is kind of just an overview again of, what's right. Again, and these are some potential scenarios, if you're expanding, you want a clean path to the green card. Again, this is where here's our pitch, right? This is where a good, experienced attorney, law firm comes in because we can kind of guide you on all these different scenarios, and I think probably a lot of people listening to this didn't realize that there were so many different possible scenarios, and sometimes you might be in a situation where you started down one path and you realized, oh, I'm in trouble, right?
Yeah, this is where consultation, it plays a huge part. I mean, I speak to so many individuals, obviously business development. I'm making a lot
Hmm.
of phone calls every day, 80, 100 calls. And the idea or the concept or the conversation of consultations always comes into play. And I really push our leads and our potential clients to book a consultation with our firm, because that's where they will get the clarity, right? It's not
Hmm.
as easy as saying, I Googled it, I fit the description, and I can do it, right? Anyway,
Right.
basically I am doing the legal staff or the legal team, attorney office, a favor of giving them my business, and it's not the case all the time, right? It
Yeah.
really has to do a lot with planning.
Yeah, yeah, absolutely. Yeah, I don't think ChatGPT is gonna give you all this information. I'd be curious, and if you've got a time, I'll run it through ChatGPT, and you give 'em a scenario. I'm gonna try to do it this weekend and see what it says. But I gotta tell you, ChatGPT is, uh, still not doing things too well with immigration law. I've seen kind of answers like this. See, people gotta be careful because people always say, "Well, I internet told me this, Claude told me that," but so, uh, hopefully we've got some job security for a while, Alex, I think, so we're good.
Okay, right on. I'm glad.
Yeah, yeah. So,
Sweet.
well, hopefully this was helpful for everybody. I think, yeah, this was a really detailed deep dive into these items. There's more information, more details in the description below for this podcast. If you want to reach out to us, get a copy of the presentation, talk to Alex, and have an initial discussion to find out, hey, what's the best path for us, and how do we go about doing that? So, sounds good. Thanks for your time again, Alex.
Thank you, Charles. Have a good one.
Thanks. We'll be in touch. Thank you, everybody.